Criminal possession of stolen property lawyer Andrew Stangl. A person who knowingly possesses stolen property without the intent to return it to the rightful owner may be charged with criminal possession of stolen property. The crime is usually charged with larceny, but may also be the sole charge. Circumstances in which criminal possession of stolen property is charged without larceny include when a person is allegedly found in possession of stolen property, but the evidence is insufficient to prove larceny, the taking of the property, or when a person allegedly and knowingly receives stolen property, such as through a purchase or the acceptance of a gift. Degrees of criminal possession of stolen property in New York. This crime has 5 degrees. 5th is the lowest degree, and 1st is the highest degree. The degree that is charged is generally determined by the value of the property, although there are some exceptions. Criminal possession of stolen property in the 5th degree is charged when the value of the property allegedly possessed is $1,000 or less, assuming that there is no enhancing element. The crime is a Class A misdemeanor, punishable by up to 1 year in jail. Even if the prosecutor's evidence is strong, there may be alternatives to a criminal conviction if a person charged has no or even a minor criminal history. Criminal possession of stolen property in the 4th degree is charged when the alleged property in question is valued at more than $1,000, but less than $3,000. Criminal possession of stolen property in the 4th degree is also charged if a person allegedly possesses a stolen credit card, debit card, or public benefit card. The crime is a Class E felony, which is punishable by 1 1/3 to 4 years in prison for a first felony conviction. A skilled criminal defense attorney may be able to negotiate for a reduction to a misdemeanor charge, or even an outcome that does not result in a criminal record. Criminal possession of stolen property in the 3rd degree is charged when the property allegedly possessed is valued at more than $3,000, but less than $50,000. The crime is a Class D felony, which is punishable by 2 1/3 to 7 years in prison for a first felony conviction. Criminal possession of stolen property in the 2nd degree is charged in cases where the alleged property in question is valued at more than $50,000, but less than $1 million. The crime is a Class C felony, which is punishable by 5 to 15 years in prison for a first felony conviction. Criminal possession of stolen property in the 1st degree is charged when the property allegedly possessed is valued at more than $1 million. The crime is a Class B felony and may result in up to 8 1/3 to 25 years in prison for a first felony conviction. Criminal possession of stolen credit cards and debit cards in New York. It is a felony a person allegedly possesses stolen property that includes at least one credit card, debit card, or public benefit card. As in all other criminal prosecutions, the burden is on the prosecutor to prove each element of the criminal possession crime beyond a reasonable doubt. One such element in criminal possession of stolen property cases is that the defendant knowingly possessed the stolen property. However, if a person allegedly possesses 2 or more stolen credit and/or debit cards and is charged with criminal possession of stolen property, there is a legal presumption that the defendant knew the cards were stolen. In New York, a related crime involving rental cars is called unauthorized use of a vehicle. To be found guilty of the crime of unauthorized use of a vehicle, a person must keep the vehicle far enough beyond the rental period to constitute gross deviation from the agreement and continue possession of the rental car beyond a mailing from the rental company demanding returning of the car. If possession of the rental totals 15 days or less, no crime is committed unless and until 7 days after the end of the rental period and 2 days after service or a certified mailing to the renter demanding return of the vehicle. The crime is either a misdemeanor or a felony, depending on certain factors. If there are no aggravating circumstances, the crime is usually charged as a misdemeanor. As a former prosecutor and current criminal defense attorney in New York, Andrew Stangl has aggressively and successfully handled hundreds of cases of alleged criminal possession of stolen property and alleged larceny-related crimes. Visit the website of Andrew Stangl for more information, STENGELLAW.com, or send an email to info@stangolaw.com. Attorney Advertising. Prior results do not guarantee a similar outcome.